Okay, so I got the message. Let me try and speak slower. Today I want to talk about the Fifth Amendment right to remain silent. I want to talk about Kelsey's Fifth Amendment right to remain silent, which she exercised her bid to become immune, things of that nature. Let's discuss that today. My name is Marcus Landsberg. I'm an attorney in Honolulu, Hawaii. This year I'm on a sabbatical, and because of that, I have all the time in the world to record these videos, and it helps me practice my argumentation, so when it is time for me to get back to work, I won't lose it all, hopefully. If I can explain it to you, I can explain it to any jury in the world. That's my goal. That being said, let's talk about the Fifth Amendment. Your Fifth Amendment gives you the right to remain silent under questioning, under color of law. So under the authority of the police, the prosecutor, anything that is under process of law. But there's two factors in order for you to be able to exercise your Fifth Amendment. Now, let me rewind that. I don't think I said that right. Actually, you can just not answer questions anytime you want. You can always not do that. But for the questions, if they are asked, for them not to come into evidence against you in court, two things have to occur. One, you have to be in custody of the police or the prosecutor of the government agency. What that means is you're not free to leave. Two, it has to be in response to, not questioning, but a statement designed to elicit an incriminating response. Now, generally that's questioning, but it's not unheard of for them to say something in front of you, such as, if only he'd tell us what happened, maybe he wouldn't go to jail. Not asking you a question, in fact, not even talking to you, but you're in the back of the police car and you're not free to leave at the point they say that in front of you as a way to, because obviously these all came from things police have done, as a way to entice you to speak. That would be a violation of your Fifth Amendment right if they did that in front of you, you responded to it, right? And then they tried to use that against you in the court of law. And this all happened without you receiving your Miranda warnings. Now, people misunderstand because we see it on TV, and TV it has become a shorthand. 2 minutes until the show is ready to finish, when the case is over, when they finally put the perp in handcuffs, we hear, you have a right to remain silent. We think that always happens, we being people who just watch TV, that always happens when people get arrested. The truth is it hardly happens in the process of you getting arrested, at least not in my jurisdiction, not in jurisdictions where I practice. The only time it happens is when they're going to take your statement from the police in order to use against you or against one of your compatriots in a case later that would end up in a court of law during the investigation. Otherwise, they almost never read you your constitutional rights. And the reason for that is you have to be a suspect in order for your Miranda rights to activate. It has to be designed to elicit an incriminating response, right? And it has to be while you are in custody, meaning if it's a walk and talk, if they're walking next to you, if you're walking down the street, they don't stop you from leaving. If you approach the cop first or you call the police on the phone to respond to a situation, all of these things are very common where they can say, hey, what's going on? Tell me what's happening. They're walking with you. You're walking down the street. They see you. They decide they want to ask you questions. Don't stop you. Or even if they do stop you, but you could have said, I want to go, and they start asking you questions, none of that invokes your Fifth Amendment right. Okay, that's the basics on the Fifth Amendment. And I do want to talk about the difference between use immunity and transactional immunity, but I'm going to do that in a minute. Let's talk about why Kelsey wanted, in this particular case, and of course, as always, we're talking about the Tory Lanez case, because it's, at least for me, it seems to be a very good balance in order to give people an insight to how criminal law works, how we can discuss criminal law, and the things maybe either you need to know to discuss it intelligently in the future when you have this information. Okay, so why would Kelsey exercise her Fifth Amendment right in this situation? There's two answers, and what I mean by there's two alternative answers. One is why she actually did it, at least as far as I believe, and one is legalistically how she was able to do it, okay? One is why she actually did it. I think it's very clear. She was Meg's good friend when this occurred. She was Meg's good friend when she made the statement to the police department, the prosecutor's office, when she sat down with them and had a long interview. And she was no longer Meg's friend at the point the trial came around. I think we could all agree by the time the trial came around, it was very clear. She had no desire to help Meg at all. She had no desire to be there. If she had the opportunity to not testify or not be a part of this, to not help participate in putting Tory in jail, she would have had nothing to do with it. I think that's pretty clear. I believe, and I don't have inside information on this, but I have enough experience where I've seen it play out. She at some point said, I don't want to be a part of this. Why do I have to go testify? And her attorney, if I'm not mistaken, it was a court-appointed attorney, but her attorney said, let me see what I can do. They waited for the state to put on their case. Now, at this point, the prosecutor has already committed in their opening statement that Kelsey is going to come tell the jury a certain set number of facts. They've already said that out there. What the prosecutor should have done is been very vague as far as what Kelsey was going to say, but they didn't. They committed 100% to it, and they did that based on the previous statement, which I don't know if they didn't follow up, if they didn't realize she no longer wanted to cooperate. I don't know how that all got involved, but by committing to that, they needed her to come testify. The morning, or maybe it was the evening before, that Kelsey was supposed to testify, her attorney came in and said, she's not going to testify. She can take the Fifth Amendment. The prosecutor said, what? The judge said, what? Everyone said, what? I think at this point, Tory's attorney said, because I think they knew what was going on. I don't buy that he didn't know that she, we kind of knew that, right? Anybody watching kind of knew that she had fallen out with Meg. So this was not a mystery to people who were paying attention. It was a mystery to the prosecution is what it looks like. So they said that, and the next step is, how do you compel someone to testify if they choose to take your Fifth Amendment? When can you take your Fifth Amendment? She would be in custody in the sense of she's being compelled to answer questions. She's not allowed to leave the stand. She's there under subpoena. She's not allowed to leave the stand in court until the judge gives her permission, which means she's being compelled to be there. And she's going to be asked questions under color of law by a prosecutor, by a defense attorney, through the power of the court if she refuses. That means her right against self-incrimination is activated. When we say it's activated, you're not allowed to, as a witness, just because she doesn't want to be there, say, well, I got nothing to do with it. I just don't want to testify. I'm not going to say what I did. Had she done that, they could hold her in jail and hold her until contempt until she chooses to testify. She could have gone in there and lied and said, and I think she did a little bit of this, whether it was a lie or not, I don't know. But said, I don't remember anything. I don't even remember that night. I don't remember what I said. I don't remember what I did. She could have said that previous statement that I gave when you guys interviewed me in your office. I don't even remember it. I don't know if that was me. That doesn't even sound like my voice. I don't know who that was. She could have forced them to go through all those steps. If she wanted to get up there and say she didn't remember because she didn't want to have anything to do with this. I have a suspicion that Tory's attorneys thought that's what she was going to do, that she was going to commit to not saying anything negative about Tory, and more importantly, not saying anything about that evening. And I think that's part of the reason why she attempted to take and did take her Fifth Amendment. So the question is, legally, when can you take your Fifth Amendment? You can take your Fifth Amendment only to stop yourself from incriminating yourself. What that means is, if you just don't want to testify, if you just don't want to talk about, hello, we're talking about the law. You want to come talk with us about the law?
Swim.
You want to swim?
Yeah.
Okay. You go swim in the pond and let me see. Okay. The question when it comes to the Fifth Amendment is, you have to be incriminating yourself were you to testify to certain things. Now, see here.
Swim.
Swing. You want to swing?
Yeah.
Go swing. Lexi, say hello. That's why we do it. So you cannot exercise the Fifth Amendment just because you don't want to testify. To exercise the Fifth Amendment, there has to be a real danger of you incriminating yourself. You'll see what the prosecutors argued in this case is that they were never going to prosecute her, so there's no danger of her being incriminated. And because of that, they don't need to give her immunity. I don't know why they fought so hard to not give her immunity. They don't need to give her immunity. Because that's what they said, the judge says, well, that doesn't give her immunity. I'm not going to let you get away with that. You have to give her something or she's going to be allowed to not testify. In federal court, it's different. In federal court, they asked the prosecutor to leave. They asked him to leave the room. And the judge will sometimes interview the attorney outside the presence of the attorney general. Sometimes they interview the attorney. Sometimes we'll interview the defendant themselves and make sure there's something they're really incriminating themselves about. Federal rules, the way that works is they're allowed to do that. State courts do it their own way. They can all do it their own way. In my jurisdiction, they'll generally take the word of the attorney, because if we're lying to the court, not only is that a crime, but two, we can be locked up in jail, and we can, most importantly, lose our license. It means I can't put food on my kid's table anymore without getting a real job to do something else. So for those reasons, I'll usually take the word of whoever the attorney is to say that there's a possibility. And in a case like this, where she's clearly being accused, at least in preliminary sort of situations by Tory's side, that she's the actual shooter, that makes sense that if she wants to exercise her Fifth Amendment, she probably could have at that point, unless they give her immunity. Once you get immunity, there's no danger to convict yourself. Once there's no danger to say something that could incriminate you, then clearly you no longer have a Fifth Amendment right about that topic. Okay. But the other important thing to remember is you don't have to slam dunk incriminate yourself during the Fifth Amendment. Sometimes it could be as much as just putting you in the location, providing one element, at least the way I was trained, providing one element towards your incrimination, that you were there. Sometimes you want to do it because you're close to being accused. Maybe you're not accused, but she's scared she's going to slip up. Let's remember, not everybody is as well spoken as you or I. Some people can't answer questions directly. Some people can't put their words together in the right sentence. Some people, especially under pressure, say the wrong thing. I just read a case about another day where a woman testified. I think she cried on the stand because she couldn't put her words together. The jury interpreted that as her confessing to killing her own child. It came out 10 years after she was executed by the state that it was a Klansman who actually did the killing. I don't have it at my fingertips. So I read about that the other day. So this type of thing is real, and it happens. If you're using your Fifth Amendment, it's in danger of incriminating yourself. So that might be something you want to, that she might be able to exercise. The other thing is, I think we still haven't put a line down as far as who owned the gun, who brought the gun to the situation, if the gun had been carried, stored properly. None of those things are what Tory's accused of. He's accused of what happened at the scene. If she was going to testify to any of those things, as far as holding a gun that maybe might not have been registered to her, carrying it outside of the proper carrying situation, things of that nature, those also she could incriminate herself. The other thing you can always incriminate yourself at is something that's not been accused yet. If the story starts with her saying, well, we were doing all kinds of cocaine, which I had bought for people, well, you would have to incriminate yourself, even if what you're going to testify to has nothing to do with, subsequently, the crime that you were testifying to subsequently has nothing to do with finding you guilty of that crime. Maybe the basis of why you would testify, right? At that time, I was engaged in drug sales. And that's why I was there that evening. Well, you can't testify, or you have a right to not testify, because your Fifth Amendment stops you from having to incriminate yourself. So what happens then is the prosecutor and judge get together, and usually the prosecutor wants the least, the judge wants the most. And what they're going to do is figure out what kind of immunity they can do to force the witness, in this case Kelsey, to force her to testify. There's use immunity and there's transactional immunity. Transactional immunity is the better immunity. Transactional immunity is anything you testify to on the stand. It's really about the material in this particular case. It's not, if you ever saw the last episode of The Shield, which is an amazing TV show from a while ago, they sort of did that differently. It worked for the TV show, it was true, but it doesn't translate this way. Transactional immunity is if you testify to I was a part of certain things, or I wasn't a part, I saw these certain things, and they want to prosecute her for that later. They can always prosecute her for perjury, right? They can prosecute her for lying on the stand, lying under oath, things of that nature, but they can't prosecute you for whatever is involved in the material of what you testify to. Well, at that point, I saw him shoot, I handed him the gun, I brought the gun to the situation. They couldn't prosecute her for any of those things if those are things she testified to. Use immunity is different. The only thing you get with use immunity is whatever you testify to. Whatever you testify to, they can't use your statement against you in the future. But if they have independent evidence of crimes you committed, even if it's about what you testified to in court, they can still use that independent evidence to prosecute you later, just without your statement or whatever you testified to. Use immunity, honestly, is not really that good, and I don't know how that was enough in this situation, but for whatever reason it was, she got up on the stand and she testified to. The Fifth Amendment for a defendant and eyewitness are completely different in their application when you get to court. A defendant always has the right to remain silent. The prosecutor isn't even allowed to try to invite the defendant to testify. And if they make an illegal comment, if they make a comment either during opening or closing, the defendant didn't tell you what happened, they had a right to testify to you and they chose not to do it. Anything they chose to do that comments on their right to remain silent in a negative manner, that case probably is thrown out for a mistrial for prosecutorial misconduct. And that's a very easy way for an early prosecutor to make a very easy mistake. That's a big problem. But when a witness gets the Fifth Amendment, right? And let me go back. For a defendant using the Fifth Amendment, what ends up happening when a defendant uses the Fifth Amendment, there's a lot of questions, at least in my jurisdiction, but I think in many, that double, triple check that they understand they have this right to not testify and they understand that they're giving it up. My understanding also is in England or in Great Britain, they've changed the law. So now if you don't testify against yourself, they said, well, juries use it against them anyway. Let's at least be honest about it and say they are allowed to use it against them. You still don't have to testify against yourself, but they can use it against you and say, well, they should have testified in their own defense. I think that's moving the wrong direction. But the way England looks at it is at least they're being honest because people were using it anyway. They just were saying we're not, but they really were. And there's always a push and pull with that in the law. For a witness to use the Fifth Amendment, it's different. A witness, at least in my jurisdiction, you're not supposed to say, I exercise the Fifth Amendment in front of the jury. You're supposed to work out which questions you're allowed to ask and which questions you're not going to ask before they get on the stand. But once they get on the stand, the questions have to be limited to only things which may not incriminate them, right? And they shouldn't generally say, I take the Fifth in front of the jury. Which is why I think there was one question where she actually might have said that. And that's weird to me. I don't know that's a reason to overturn the case, but it is a very weird situation in that process in the Tory Lanez trial. So far, I told you why she didn't want to testify, which is her feelings, which I think she just didn't care to be a part of it anymore. Two, I told you legally how she was able to not do it. Her attorney went in and say there's things that she could... there's a reasonable basis to believe there's something she could testify to based on these questions that would lead to her incrimination. Doesn't mean her incrimination of shooting Meg. I know everyone wants to interpret it that way. That's not what it means. Her incrimination on something, right? Number two. What's the third thing we wanted to talk about? Oh, so the most important thing, the third thing, is why the attorneys didn't want her to testify. And I touched on this, but let me just drive the point home. If Kelsey never testifies at all, the previous statement she made to the prosecutors cannot come in any way. There's no evidence. If you want me to go through the hearsay rules, I'm happy to go through some of them for you. But there's no way it comes in. There's no exception where these pieces of evidence can come in. That's number one. If she does testify, there's a number of rules and exceptions where they can attempt to get this previous statement in. And you saw them do it multiple times until the defense did what they did. There's a number of different ways you can attempt to bring it into evidence. The first one is if they say they don't remember, you can say, well, do you remember giving a previous statement? I'd like to refresh your memory. Or would that statement refresh your memory? We also call it refreshing recollection. This is a 100-plus-year-old rule, so they have odd names. But it's called refreshing recollection. Can I show you the statement? Maybe it would refresh your recollection. They read it, they look at it, they listen to it. They think about it, and then you ask them, once you take it away, you say, is your recollection now refreshed? That's the magic words. If they say yes, then you just ask them the same question, and they can answer the same question, okay? If they answer, yes, that's what I said earlier, no, it's not what I said. If they say no, if there is a commitment that what they said previously is not the same as what they're saying now, if there's a commitment that what they say is not what they're saying now, then what ends up happening is you go into the prior inconsistent statement mode. Prior inconsistent statement is when you commit, credit, confront. That's the process. So you commit them to their current statement, whatever they're saying now. No, I never saw XYZ. Then you credit it. Isn't it true that you came in my office, we had a conversation, such and such person was there, this nice lady with the haircut, right? And you go through that process. That's you credit the previous statement that they weren't under pressure, the defendant was not in the room, you weren't looking at his family in the front row, you didn't feel bad, things of that nature. And then you confront them. Isn't it true on this particular date, during that interview we just talked about, what you said was? And you read the statement. And they can say yes or no. And usually they'll admit to the previous statement, yes, right? The prior inconsistent statement. If they say that, then they're stuck where they are impeached on what they said currently with a statement they made previously, and the jury has to believe, are they lying to us now? Are they lying about other things? And that's the way that process goes. So why did Kelsey want to not testify? Very clearly, by this stage, she did not want to be involved. And I think she did not want to have anything to do with putting Tory in jail, especially if putting Tory in jail is what Meg wanted. That friendship had sailed. The legal reason that I just explained, that's how they processed it. When they said, no, she does have to testify because she only got use immunity, that she still does have to testify, she was in a weird situation where she didn't want to lie, but she also didn't want to put Tory in jail. And I think the way she testified, the way it's been reported, the way she forgot things, was sort of obstreperous about different things, walked the line a little bit, went back and forth, denied certain things, but was adamant about the fact she never touched the gun because she didn't want to go to jail, like she didn't want that. Because of that kind of situation, because this is what would happen, let's be very clear. If he had won the case based on the fact that she either testified or there was some evidence that she was the one who shot him, right? They couldn't, with use immunity, they couldn't use her statement against her in the next trial. But had they wanted to, they could use all the evidence that was brought in and built the next trial based on that, except for the previous statement. And had they not, there would have been a big problem with the community. I believe that this woman either admitted to it or got fingered for doing it, and now you're not going to prosecute her. Why? Because she's a woman, because you don't believe him when he says it, any of these things. These are all real issues. So because of that, I think she had to be very adamant, at least about the one thing that she really committed to, was that she did not fire the gun, right? And that's what I tell you. So as far as this goes, I hope that explains why she used the Fifth Amendment and how she got to use the Fifth Amendment. Not that she admitted, I think there was one comment that she admitted to the judge in the back that she must have done it. Because of that, she got use immunity. That's clearly not remotely on the planet of what could have happened. But yeah. Thank you for tuning in. It really helps my ego if you would to like and to subscribe to these videos and watch them as they come out. If you do have more questions, especially if it's on another topic, I'm trying not to get all my views based on Tory Lanez. If there's anything you do want to talk about, go ahead and put them in the comments. I'm happy to answer what I can. And if I think I need to make a longer answer or talk about it, I'm happy to make these anytime I go to the park or go somewhere cool that I want to show you. Look at this place. It's dope, right?